it is difficult to interpret what the law or the regulations or the notices say. So now in the guidelines, they always provide you with examples, with illustration, right? In order to fill up the gaps, right, for you to be able to better understand how the Act, the regulations, and the notices will play out. All right, how these how the provisions of the Act, the regulations, and the note are being played out in the real market. So the examples are important for you to take a look, right? Right. So, as I said, they give you a warning as well. The failure to comply with the guidelines may be relied upon to establish or negate any liability in question in relating to any proceeding under the financial advisors regulations. Right. Right. If somebody were to complain and somebody was to allege whatever allegations they want to make, all right, in terms of conflict of interest, in terms of mis-selling, etc. All right, so if you fail to comply with these guidelines, like I've said many times over this program, there are consequences, right? Although on the one hand, we say guidelines do not really have the force of law, they are for best practices. But on the other hand, you can see clearly that if you do not comply with the guidelines, you don't follow the guidelines, especially when it's done willfully, willfully, deliberately, you do not want to follow the guidelines, all right, then the failure to comply with the guidelines may be relied upon to establish or to negate any liability in question, right? Right? Failure, that means, well, you are liable, right? To any issue, to any question relating to any proceeding, right? Any proceeding in relation to the Financial Advisors Act or the Financial Advisors Regulation. All right, and of course, they make sure that you understand that these guidelines should be read in conjunction with the provisions of the FAA. That's what I was trying to tell you. The FAR, as well as the written directions, notices, codes that the MAS may issue from time to time, right? So the long and short of it, all guidelines are important, right? And they write a lot of things into these guidelines so that you cannot say that you don't understand, right? The notices or the regulations or the Act itself, right? They are giving you examples, illustrations, scenarios, right? So therefore, there's no excuse for not knowing how the laws will play out. Right? So very quickly then, you look at internal policies on research activities, and that's governed under paragraph 5, all right? All the way, if you turn the page all the way to 25, right? So here the guidelines are pretty comprehensive, although it is not exhaustive, right? So you need to look carefully at these paragraphs in your own spare time or in your own time to understand the necessary to avoid conflict of interest situations. All right, when the financial institution or the financial advisor issue research reports or research analysis, in particular relating to any conflict of interest. All right, so you need to manage any potential or actual conflict of interest. Right, now in particular, look at paragraph 7, right? So the internal policies and procedures should address conflicts arising from A, trading activities and financial interests of the financial institution and its analysts. All right. So even if you were to work in the bank, for example, I used to work in the bank at one time. So if you buy certain shares and certain securities, you need to inform the bank, all right, that what are the holdings that you have, especially when you are doing sales and giving advice or recommending products, right? So you need to know whether there are any potential or actual conflicts. So A, any trading activities and financial interests of the financial institute and its analysts, right? Because the analysts are doing the writing, doing the research, all right? And therefore, if you have holdings, so that may again prompt you as a natural thing, all right, to write in favor or otherwise of a particular product or particular service, right? Then B, reporting lines and compensation and the analyst, right? So where and so on, right? influence from business relationships or financial institution and other external parties. All right, so any cross holdings of this particular financial advisor or financial institution, right, that may give rise to conflict. All right, and of course the third part there, the second part there, standards of disclosure. Right, so the disclosure must be upfront and complete. Right, then they give you some details about what does trading activities and financial interests mean. So the whole thing is from paragraph 8 all the way to 12. Okay, that's under paragraph 7(1)(a). They give you details there. Right, and you can see that the amendments are done in October 21/8. Right. It's about 2 years ago, less than 2 years ago, 19, October 18, October 19, and October 2020. So yeah, all right. So it's pretty recent because as I said before, as time goes by, so new things come in, and then they were amend accordingly. Okay, all right. Okay, now just to end up this particular one, look at paragraph 12, right? If you look down the paragraph 12, the long paragraph there, they talk about the blackout period, right? Right. So I just read to you that particular line where you can see blackout twice in inverted commas, right? So those are the blackout period. I just read to you, in this regard, is 1, 2, 3, 4, 5, 6 line down, paragraph 12, right? In this regard, the financial institution should have a policy in place for an analyst and other staff, right? Like what I told you earlier from my experience when I worked in the bank, and other staff of the financial institution with access to non-public information in the research reports that mandates a blackout period, right, for trading of those investment products before and after the issuance of the research report. The financial institution should assess what is a reasonable blackout period to be imposed and take reasonable steps to ensure that such analysts and other staff do not circumvent, right? Do not circumvent any trading restrictions by encouraging or arranging for others to trade in those investments products during the blackout period. All right. In assessing what constitutes a reasonable blackout period to be imposed after the issuance of the research report, the financial advisor may take into consideration whether the recipients of the report, right, would have a reasonable opportunity to act on the research information and recommendation therein, right? So there is therefore a need to be concerned about paragraph 8 to 12. Okay? Okay. Right. So that covers paragraph 7, internal policies to address trading activities and financial interests of the financial institution and its analysts and its other staff, right, in terms of any actual potential conflict. All right, now if you look at paragraph 7(1)(b), that's the top about reporting line, and that's we're given at paragraph 13(1)(3). All right, so that the reporting lines and remuneration policies, right, how you pay your analysts, should be structured to ensure objectivity by eliminating, and while this is not possible, effectively managing conflict of interest, right? So the financial institution should ensure that analysts are separate from staff who are performing the sales work, the sales trading. So it must be separate department, right? So Chinese walls or whatever walls should be erected, right, to ensure that there's no collusion, as it were, between the departments, right? Right, and you can see there at paragraph 13, right, performing sales trading, dealing, corporate finance advisory, or any other backroom office function that may affect, under the word, independence of the analyst. All right, so those who are doing research analysis, research report, right, they must be separate and different from the frontline people, as it were, or even the other backline office function. All right, that means they must be independent. All right. Separate reporting lines should be in place between the analysts and staff from other corporate or business functions, In particular, research reports should not be reviewed or approved by the sales, trading, dealing, or corporate financial advisory service or any other business function, right? In order to avoid a potential conflict of interest, right? So we don't want a situation where the analysts are being influenced by the salespeople, all right? And in which case they'll write something which is not independent and not objective, and therefore it creates conflict of interest. All right, as you well know, the frontline people normally are more interested in revenue, sales, right? And they are pushing certain products, all right? Whereas the research analysts are supposed to be independent based on their visits to the sites of companies, maybe, all right, or from other documents and from their own independent research, so that they can write an objective research report. Right, or do more objective and independent analysis in terms of issuing the research or the analytical reports. All right, and then 14 talks about remuneration. That analysts should be structured in such a way to avoid any bias. All right, in their research analysis and the research recommendations. All right, because in the hands of analysts is a powerful instrument, right? So whatever they write, they say, look, I'm an expert in this particular area of financial advice or financial products, right? And as such, whatever I write appears to the public to be important, to be a fair and accurate representation of the potential or otherwise of a particular product. All right. So in which case, people will look at the research analysis or the researcher's recommendation to be unbiased. All right. So in particular, here it said the analyst bonus, salary, or other forms should not be based on only sales target, only sales, trading, dealing, or corporate finance advisory transactions. All right. So his pay, his bonus must be separate and independent. All right. Okay. So that's in regard to the paragraph 7. 1, conflict of interest arising from trading, and 2, reporting lines and compensation of the analyst. All right. Then the next part is influence on business relationship of financial institution and other external parties. All right. So that is also another potential area where conflict of interest will arise, and they can arise most of the time, right? Right, you look at the paragraph 16, issuers and the stakeholders. All right, so what are stakeholders? Look at note 3 there below. Stakeholders are your substantial shareholders, substantial unit holders, right? Persons with conflicting interests. All right, these are the people who may want to push, right, a certain point of view, right, and therefore they may influence the analysts, right? So here we are talking about business relationships. All right, so 1, 2, 3, 4, 5, right? So look at 5, the 5th line from paragraph 7. All right, so that is the issue about favorable research, favorable reviews, right? I just read to you quickly this one. The financial institution should not offer favorable research coverage as a consideration for business or compensation, right? So that is the issue. I just paused there, right? Accordingly, a financial institution should have an adequate basis supported by research for making a research recommendation, right? It should not issue a research report or recommendation that is not consistent with its analysts and actual views regarding a subject company. Right? So if we have some relationship with another company, and therefore you tend to write more favorably, all right, in your research reports or your research recommendation with regard to that company, right, that you may have a business relationship with. Right? And the paragraph 16 talk about issuers and stakeholders having vested interest in the research and recommendation provided by analysts. Right? And because they have a vested interest, therefore, they will seek to influence the analysts to issue favorable recommendations. All right? So as such, the financial advisor must put in place procedures, right, to manage or to mitigate or to eliminate underline the word undue influence, which I've said a couple of times ago. Is undue influence of the issuers, the institutional investors, and other external parties on its analysis. Okay. Right, and of course 17 talk about robust and effective information system to access barriers, right, to ensure independence and objectivity. So you must put up walls, the firewall, Chinese wall, whatever walls that you may want to look at, to ensure separation of function and separation of reporting lines and things like that. Alright, then very quickly, standards of disclosure, that is clear and prominent, not misleading, is the same issues that we have seen across this particular module. Alright, so the standards of disclosure are high as stated earlier. Alright, so yeah. And I just want to read from paragraph 18 to 23, I just want to highlight paragraph 22. Alright. Right. So the standards are similar, clear, right? Prominently written, right? And not misleading, adequate, sufficient, right? Now, more importantly, 22, the financial institutions disclose in its research analysis or reports any corporate finance advisory relationship, right, between the financial institution or its connected persons and issuers of the investment products being covered in any research analysis or report over the past 12 months, or any other relationship that may create a potential reason for conflict, right? Right, so there is a time frame there. Right, so then I move on quickly. The last point on this particular conflict of interest guideline is paragraph 25, and it's a similar thing, right? There are timelines involved. Maintain proper records and the basis, and here not more than 5 years from the date of publication of the research, right? So there's a minimum of 5 years there. Again, is when to make sure that documents are readily available in case there is any complaint, any lawsuit that may come about rising from potential actual conflict of interest situations. Okay. Now then, very quickly, now we look at 11B, Appendix 11B, last revised 29 June 2018, guideline on online distribution of life policies with no advice. Right. Right. So paragraph 5 straight away there, it took effect in the 31st March 2017, a couple of years back. And then the definitions, I believe we have done that in the earlier chapter on the notice on this online distribution of life policies. Right. So online direct channel, the definition under paragraph 6, in relation to a life policy means any web portal, alright, any web portal or application in the internet created, developed and maintained or operated by any financial advisor on which a client may purchase a life policy. Alright, so that's the definition of online direct channel. Is quite clear cut. Alright. Now then, paragraph 8 talks about offer of equivalent direct purchase insurance products. Now we have covered that earlier, so I'm not going into detail on that one. Alright, but just to illustrate the point, 1, 2, 3, the fourth line there, paragraph 8. To illustrate, a financial advisor which intends to offer a whole life insurance policy on its online direct channel from an insurer is expected to also make available that insurer's whole life DPI on its online direct channel. Alright, so you cannot just put the product that you are offering. If there's equivalent products from the direct insurer, then the financial advisors must put the same on the online direct channel as well. Well, this is to facilitate comparison, right? The one that is offered by the financial advisor and the other life insurance, the other insurer's whole life policies of the particular insurer. Now then, 9 give you I read 92. The authority has not required all financial advisors to offer the DPIs online, right? So there's no requirement for all financial advisors to offer a direct purchase insurance online, right? Because MAS recognizes the fact that not all financial advisors have an online platform for the distribution of life policies. This is a practical thing. All right, so MAS cannot require all financial advisors to do that, right? Because some of the smaller financial advisors may not have the online platform yet, right? Or they don't intend to have this DPI policies to be given online. All right, right. They emphasize the point at paragraph 9 that, however, where a financial advisor has an online platform to distribute life policy, it should also offer the equivalent DPI online to its client. Right? That's a repetition there. Right? And very quickly, provision of key information, that's clear, right? Because you are going online. So you make sure that you have everything that's online. And the example given to you in this guideline is number 1. All right? Cover page, policy, illustration, product summary, the whole works. All right? Then full policy wordings of the relevant life policy. All right? And then financial advisor should also obtain the client's acknowledgement that has completed the item set up in Annex A. All right? So as it is the case online, so it must be comprehensive. All right? So that the client can make an informed decision. All right? Now B talks about conditional acceptance. That's in relation to whether there's a need to exclude pre-existing medical conditions. All right, and if there are pre-existing medical conditions, whether there are any additional premium loading imposed by the direct life insurer due to the client's pre-existing medical condition. All right, so there must be acknowledgement of the conditional acceptance so that there's no dispute. All right, that the customer knows about the conditions, right? The conditions before buying the life policy. Right? Then paragraph C talks about the incorporation of prominent statements. This is online, right, without advice. So before a client completes the purchase of a life policy via the online direct channel, the FA should highlight an alert to the client, such as a pop-up reminder, right? Something that pop up from the screen that says the following, right? And of course, all these pop line things should be simple, concise, prominent, direct, clear, use simple language, etc. The standards for disclosure. All right. C1. A life policy is not a savings account or deposit. Client may not get back the premiums paid partially or in full if the client terminates or surrenders the policy. All right. Some benefits of the life policy are not guaranteed. All right. Only if it's applicable. Then 14-day free look period. I can ask the financial advisor to explain the product features. Even though it's online direct, you need to you may have a duty to explain to the client. The client may wish to separate seek financial advice on the suitability of the product. Ask the client to do that. Well, I'm going to ask another financial advisor or ask whoever that you are comfortable with, that the people who are qualified to give you the advice. In the event that the client chooses not to seek advice on the suitability of the life policy, the client should consider if the life policy is suitable for his financial circumstances and the needs. All right. Again, this is to protect the financial advisor. Right. So all these things must be clearly, prominently displayed on the online direct channel. Right. Whether it's a web portal or a website or whatever that the financial advisor chooses. Right, to market and distribute the direct purchase insurance products. All right, now there's a line below there that says these statements under C1 to 7, 1 to 7, yeah, should be worded in a simple and concise manner. All right, use simple language, plain English. All right, we'll talk about the next one as a provision of tools and calculators and considerations of other types of policies. All right. So a financial advisor should encourage his client to go through the items set out in Annex B, highlight to the client, before buying the life policy via the online direct channel, and include the following. Alright, under paragraph 11A to C, right? Calculate the amount of life insurance coverage, right, so that the client can determine if the life policy meets its protection needs. Check the premium is payable and is affordable based on the client's income and expenses for the month, right, or for the year. Consider the different types of DPI and other types of life policies available. Now, this is a point where the equivalent direct purchase insurance product should be put online as well, and whether the life policy is suitable, right? So you allow the client to compare the one that's offered by the financial advisor, and by the insurer concerned, right? All right, the safeguards set out in paragraph 11 may not be applicable for all types of life policies sold via the online direct channel. All right, now here they give an example. For example, a financial advisor which offers monthly renewable group life insurance policies via the online direct channel is not expected, right, to make such tools available to the client, as it's not a long-term financial commitment. So again, it's a case-to-case basis as to what kind of safeguards that you are required to do. All right. So then, of course, handling of queries, we have talked about that one. Right. So avenue for the potential or the prospective customers, or even the existing customers, or persons who have bought the insurance policy to file complaints and so forth. Right. The implementation of internal control policies and the procedures that we have gone through. Right. And in terms of technological risks, we have covered that under the PDPA, and also the downtime risks. All right. So system security, reliability, resiliency, and recoverability. All these are the management tools that the direct life insurer must have. Right. All right. And then, of course, the business continuity plan. Right. Any component failures to the online direct channel to ensure continuous functionality and operation. Right. Now then, paragraph 19 is again in terms of application of the guideline. I just wish to repeat that. Where the authority is not satisfied, right, with the financial advisor's observance of the guidelines for this particular direct purchase insurance products notice and guideline. So if the MAS is not satisfied, then the MAS may require the financial advisor to take additional measures, right, to address the deficiencies noted. Right? So you need to comply with this one. And then across the page, the Annex A talk about the acknowledgement. Right? So the client has to take a look at this one. And I just want to read quickly to you to drive home the point. Under Part A, it says, I acknowledge that I have read and understand the cover page, policy illustration, and product summary, including any coverage exclusion. I completed and disclosed fully and truthfully all the information requested in the proposal form and any supplementary questionnaire. All right. Now this is law, so the client need to be warned. The client need to be cautioned of his duty to complete and disclose fully and truthfully all information. All right. This is the absolute good faith thing, absolute good faith principle. And if there's any shortcomings in that, then the liability will fall back on the client, right? Because they acknowledge, they have read that, and they have completed and disclosed fully and truthfully all information requested, right? Right. That's in terms of the acknowledgement for Part A. And Part B only applicable if medical and moratorium or financial undertaking are conducted. So when there's a moratorium on this, so C, I declare all pre-existing medical conditions in the proposal form. I review all existing life policies that I own or am in the process of applying for in the proposal form, and declare my current financial situation